The case is entitled Bonner versus Bonner. Both parties are present. Oops, I gotta do that. All right. Both parties are present together with the respective attorneys. Mr. Colvin for Miss, is it Stimmel? Stymel. Now it was Bonner. And Miss McCallum for Mr. Bonner. Mr. Bonner, I think is all I've got's a gray screen. I don't know if he's there or not.
Yes, I'm here.
All right. It's a motion brought for custody by father, also parenting time and a school change. This deals primarily with Lillian, who is 12 years old. There is another child involved with this who turns 18 on the 13th, about 2 weeks from now. So it's not practical really to deal with that child and custody change and things like that. We wouldn't even have a hearing until he was of age. There was a judgment of divorce that was filed in this matter in 2017 that gave 50-50 custody. Father's made several allegations. I read his allegations in the report. I've also obtained and read your response, Mr. Colvin. I'll turn it over to you, Ms. McCallum, for anything you want to add.
Thank you, Your Honor. I just would like to add that my client has tried desperately to give Ms. Stimmel as many chances as possible. He thought that she hit her all-time low when the CPS investigation happened and she was charged with DV against her husband, who she is now going through a divorce with. But unfortunately, things have only gotten worse. The children are reporting more and more incidents and more concerns when they come back from their mother's house.
Incidents of what? She's getting a divorce, and it's my understanding she's divorcing the guy, and the guy probably doesn't even live there.
Yes, the incidents are now directed at the children. All of the anger and erratic and abusive behavior are now directed at the kid.
You have of that. I mean, here's the problem. You start out, and the whole basis of your case is from February of 2023. That there was a CPS report, and the CPS report, I'm going to read right from it. This case will be denied because no child was placed in harm's way. It says right there. Children mostly were hearing through adults what was going on. I'm assuming it's through your client and through the other one. That's what it says. Quoting right from the report you sent in. Denied because no child was in harm's way. They didn't substantiate. They're not on central registry. Nothing from it. It's just like somebody investigating you for bank robbery, and they say, gee, we don't have anything, and a year later they're still saying, yeah, but you know, she was involved in bank robbery. It was an incident. No children were harmed.
That was an incident in the past that has led to it was provided for context. Notably, that CPS report also has the children's statement saying that they don't feel safe at mom's home, that they could tell their mom was drugged up during the incident, and there are continued issues.
No, and there were neighbors who thought you looked like you had done that bank robbery, but they did some investigation. They found nothing. They substantiated nothing. There's nothing. So go ahead.
We also have the affidavit from the plaintiff's sister saying that she is concerned for the children. The children have made reports to her as well about issues they've had at their mom's house and that they feel unsafe there. And she has stated that her sister has a history of violent behavior and she is fearful for her life and the life of her niece and nephew.
I have a response that says that she's seen the mother 2 times in a year. And I've got also response from another sister and her mother that contradict that completely.
Those statements, we believe, are not actually from the mother and sister. We have reason to believe that they were written by Ms. Stimmel, and they are very questionable, and I would like the opportunity to be able to cross-examine those witnesses. I do not believe that they are actual affidavits that were notarized.
They're not affidavits, they're just statements that are written.
Yeah, and I seriously call into question the validity of those. If you look at the 2 letters, they appear to be written by the same person, and they do not appear to be valid, and so I would like the opportunity to.
So you're treading on really thin ice, because if they were written by those people, you're basically calling Miss Stimmel.
Well, I'm sure we could get that.
And I'm just saying, if it's shown that they did write it, because what you're saying is she committed fraud on the court. All right.
I have serious reasons to suspect that, Your Honor.
And Mr. Colvin, how do you respond to that?
Well, Your Honor, I, I'm a little shocked here. There's absolutely no evidence of any type of abuse for the children, and now we're saying that a letter signed by the mother and the sister is somehow fraudulent. My understanding is that they signed those letters. I received them from my client. I didn't receive them directly from them, but we had a week to prepare to get our response in. Regardless of all that, too, I mean, there's nothing there. We have a sister who barely sees her saying she's a horrible person. So let's take the kids away. I mean, there's just no evidence here of any wrongdoing. There's no investigation by police or CPS. There's no even allegations of abuse. What happened is mom punished the minor child by taking her phone away. So she went to dad and complained a lot about it. So dad said, I'm going to fix this and I'm going to take away custody. That's the bottom line here.
That was one of many instances. It's not only that the sister has had contact with these children, though, and she's saying that the children are reporting to her recently that they feel unsafe at mother's house. There is also the text messages that Ms. Stiemel has sent my client that are erratic and crazy and have support all of these reports that he's getting.
I'm not that concerned with those. I don't find them to be. She's talking about you should abide by my rules because I've abided by your rules and stuff like that. They might not be the most coherent, but I don't find that warrant her being, just playing off the rails. Show me something that she has an alcohol problem. Show me something that she has a
her sister states in her affidavit that she has an alcohol problem. We have evidence from statements from her ex-husband, who we would call as a witness, who has witnessed her alcohol use and drug use. We would also call other witnesses who have witnessed these things. This is a Friday morning motion hearing. We can't bring these witnesses in.
I understand, but they don't seem to rise to anything at all. Do you know how inherently unacceptable an ex-husband's claim about his ex-wife is? I mean, do you know how skeptical that is? Do you know how, just like mom coming in and saying Miss Stiemel is a great person, that's about the same thing. He's an ex-husband. They're in the, I'm sure that for the last year it has not been great for the kids, I'll tell you, because they've been involved in divorce and stuff like that. They probably do like the stepdad. I don't know if they like the stepdad or not. Yeah, there's plenty. I'm trying to find, what are your specific statements about change of circumstance or proper cause? Which factors does it relate to, and which
well, I think change in the family unit.
I'm not going to do that because she's divorced. That isn't a change that would have me have a custody hearing. What else?
The reports from the children of her backhanding them, her chastising them, her own text messages that we submitted to the court have her inappropriately telling the children that she's having adult conversations with other people. She's having
adult conversations with other people. The mother is?
Yes. Well, she's telling the kids that. She's saying, well, I'm talking to your dad about XYZ and how it's inappropriate and he should do this and he should do that. And it's text messages to the children.
Tell me what factor that affects. Tell me how it meets Vidvarka. You got to meet Vidvarka, and off the top, I don't see it. I mean, the children saying what? That they're not happy with mom sometimes. I'm sure they probably have said they're not happy with dad at sometimes too. They come to run everything.
They come to Mr. Bonner's house not infrequently when it is not his parenting time, trying to get away from plaintiff and telling him all of these horrible things that their mother is doing to them.
Basically, then what you're saying is this is because the kids are saying this stuff. I don't have any evidence of it, but the kids are saying this stuff.
We have evidence in the witnesses who we would be able to have come testify at an evidentiary hearing to explain what they have witnessed.
Explain what they have witnessed. All right, Mr. Colvin.
Your Honor, I think it's clear that this does not meet Vidvarka. I mean, this is a fishing expedition in the middle of her divorce, which is already settled. The other parties moved out, but it should be noted that her ex-husband said, I'm going to use this against you. I mean, this has been, the fact that she's getting divorced is the main reason here. Everything they're basing their entire case on is hearsay, and not even hearsay of abuse or hearsay of some horrible issue, but hearsay of I don't want to be with mom, or I like stepdad. This is far below Vodvarka and doesn't warrant any further investigation or hearing. There is no CPS or police investigation. There's no actual evidence of abuse, neglect, or any change in circumstance great to affect these minor children. And one of them's almost 17. I mean, I'm almost 18 here. So as the court noted, that he's kind of off this case, but we're not talking about children who don't have a voice here in themselves in order to say, hey, mom's beating me or mom's passed out. None of these allegations are there. This is the minor children have said something to dad or are frustrated about the divorce or like stepdad, and this is all hearsay. So we should now get to go through everyone that doesn't like mom and bring them as a witness to say, I don't like mom, she's a bad person, so now let me have custody. It's far below the standard. We shouldn't even be talking about a change in custody or school based on what was filed here, and we asked for it to be dismissed.
Well, I mean, I'll tell you, the closest that they come is to having a threshold hearing, because you deny this and she says this and she says that. And I mean, I would not entertain a custody hearing at this time. The most I would entertain is, okay, you come in, I'll give you some short period of time on a threshold hearing. And one thing you better prove, Ms. McCallum, is that those letters were not signed, and that those two people did not agree to that also. I mean, for all I know, maybe mom wrote them up and said, Mom, this is what I did. Yeah, that's absolutely true. And you can file that. That's fine. If she just plain made it up and the mother never even knew about it, then, but because that's what you're saying. You're saying her mother had nothing to do with it, and those are incorrect statements. And if that comes out, you're making an allegation that's really serious that you better be able to prove, not just, well, maybe, that kind of stuff. That's serious allegations that you're making. And you better understand that coming into this. All right, the most that I would do, and I think the most that I will do at this point, is I will set up a threshold hearing. It's not going to be right away, because I don't have time available right away, but we'll get you probably 2 hours each. So I'll need a 4-hour block of time, some afternoon or morning or something, as quick as we can get it. And you can have a threshold hearing to make your arguments as to whether or not there is threshold through Vodvarka to even get to a custody hearing. So that'll be the order of the court. As far as school change and stuff, I mean, I'm assuming you wouldn't try to change the 18-year-old's kid's school, because he's probably going to be a senior this year. It'd only be for the 12-year-old. Are you suggesting that is still going to be there, or is that only going to be there based on a change of custody?
There would also be the change of school issue, yes.
What is the reason for the change of school?
The reason for the change of school is, partially the change in custody, and that there's a great distance between the two school districts, and the transportation is an issue.
Well, transportation, I guess, would be an issue for either parent if you change it. What is, isn't it Rockford and Cedar Springs or something? Or what are that's not great. They're next to each other. What are you saying? Your client doesn't want to transport the child or something?
No, just busing is not available for my client's location, and
Busing wouldn't be available for Miss Dimel if they go up to Cedar Springs, right?
That is correct.
So it's your burden to change the school.
And I believe the change of school is an inquiry based on what school is best for the child.
Child,
What
ever gone to Cedar Springs schools? Has the child ever gone to Cedar Springs schools?
No. Not that I know of, no.
So why would it be better to go to the Cedar Springs school?
Better academic opportunities and other...
Better academic opportunities than Rockford?
Your Honor, I just know that my client would like to send the kids to the Cedar Springs school, and we would like to present evidence on that.
And I'm assuming you adamantly oppose that, Mr. Colvin.
Yes, Your Honor, that's correct. There's no basis for that.
I can't imagine that there's a basis for it, other than it's more convenient for him. I understand if custody changed, that clearly there'd be an argument, but I'm not sure that I can just plain say no if he's made that request, but unless you have something more than that and we have a hearing on that, there's a good chance that all the costs, if you lose, are going to be yours, Ms. McCallum. Because I don't really find anything other than, better opportunities at Cedar Springs. I live in that area. Better opportunities than Rockford? I don't think so. I don't think it's a school that is rated higher, but it doesn't matter anyhow.
I think the
it's just
class sizes are
transportation.
different.
What?
My child will be going to high school soon, and there's concerns of overcrowding and high population at Rockford and things of that nature as well.
Well, if that's going to be the case, I think you're going to have a real uphill battle. And to me, it's kind of frivolous, but I'll set up a Lombardo hearing. I don't know. We'll get it whenever we can. You want the threshold hearing first, or you want the Lombardo hearing first? Because those are both, you're going to have a Lombardo hearing that's not going to give you a lot of time either. You want which one first?
When are we going to be able to get in for the hearings, I guess?
I have no idea. I mean, I don't.
Booking out into the end of September right now.
She's booking out into September.
Would there be any chance to have them at the same time?
Doesn't seem like it'd be very efficient.
Wouldn't it be more efficient to have the hearing all at once?
Okay, I anticipate, quite honestly, that the only way there's a valid school change is if there's a valid custody change, because everything you've said to me is simply garbage. But I'll have the hearing, and we'll set up the whichever hearing you want first. Which one do you want first?
The threshold.
All right, we'll get you a threshold hearing as quick as we can, probably in September. Mr. Colvin, anything?
Nothing additional, Your Honor. No.
All right. I mean, I know I'll just put on the record, I'm sure you oppose the threshold hearing because you don't think there is any, but I'm going to have a hearing because there are two sides to this story, and I'm going to hear it, and then we'll see what I determine.
Understood, Your Honor. Yes, thank you.
All right. Let's see, somebody's got to draft the order. Ms. McCallum, it's your.
I'll draft the order, Your Honor.
All right, you'll draft the order. Thank you all very much. Good luck. Thank you.
Thank you.
Adjourn. Motion brought by the prosecutor. Ms. Chavez, the plaintiff, is present. The prosecutor, Ms. DeHaan, is present. The defendant, Mr. Bowden, is not present. This is a request to enter a judgment of paternity. Ms. DeHaan, can you explain?
Yes, Your Honor. First, prior to beginning, I would like to bring it to the court's attention that the documentation that we submitted to the defendant was returned to us yesterday. It seems that the clerk had the apartment number missing on the paperwork that was mailed out. However, we did email him a courtesy copy the same day the papers were sent out to his email address. So I would like to request that the court make a determination based on notice prior to proceeding.
Well, I got other questions other than that, whether there's notice or not. When did you get him the email?
It was on June 4th, Your Honor.
June 4th, so quite a while ago. It's my understanding that he has really not cooperated with anything.
That would be a correct statement to make, Your Honor. Yes.
Now, do you know any other address to send it to?
No, Your Honor. He was very secretive about his whereabouts. When I last spoke with him on the phone, I did request that he confirm his information with me. He refused to provide me anything. He refused to provide me an address. My notes, quite frankly, state refused to provide me with his address and states he's staying at a hotel. He refused to provide me the hotel name and address. I explained that we had the address in our system, but he refused to confirm if it was updated or not. It is believed that that is the address of his significant other. And then I did explain that we would email him a courtesy copy, and he did confirm his email address with me during that phone call. When I requested any information regarding his employment or anything that I would typically collect in a pre-hearing conference, he refused to provide it to me. He said he would let the judge know at the time of the hearing. and then the call was terminated.
And then he did give you his email address.
That is correct, Your Honor. And we did email the documentation to that email address.
That's the only way you really have of contacting him.
The only true way where we actually can, yes, but we do have his last known address, but he refuses to tell us where he actually is.
But you sent it to the last known address?
The last known address, but the apartment number was missing from the address line.
All right.
It was returned.
Also in this case, is there a reason? I mean, quite honestly, you have no problem whatsoever. Was he defaulted in this?
No, so Your Honor, we had this case, it's a one-man paternity case. Miss Chavez has been extraordinarily cooperative with our office, and explained to us that, Mr. Bowden is the only potential father in this matter. When we were able to serve him, he reached out to our office and began explaining, these various allegations of domestic violence that Miss Chavez had, allegedly, committed towards him. I pulled police reports, Your Honor. APA Michelle Smith-Lowe and I had multiple conversations about this case. I had a meeting with the defendant himself in our office to discuss all of these alleged accusations. It was determined that our office would proceed with this case. We found no reason to dismiss the case for prosecutorial discretion, again, having reviewed all the police reports and heard defendants' statements. I explained to him multiple times that genetic testing was available to him. He refused to genetic test. He said he did not want to do genetic testing. I explained to him that I would proceed with this case. When it came time to default him, I explained to him over the phone that I would set it for a court hearing. Due to the complexities of this matter, the refusal of the genetic testing, these allegations of domestic violence, the case was extraordinarily complicated. He was extraordinarily argumentative, very defensive.
Couldn't you just have defaulted him because he never answered and bring a default judgment here?
I could bring a default judgment. I did file a judgment of paternity and UCSO with the calculations as a ways of default, but would prefer to have done it in front of the court rather than the procedural filing the paperwork, wait the 14 days.
Okay, Miss Chavez, do you have video there?
I'm not on video, but I can see you.
Yeah, well, could you be on video?
Yeah.
Please raise your right hand. Do you solemnly swear affirm testimony given in this case is the truth, whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. You've alleged that Mr. Bowden is the father of, is it Ilya?
Isla?
Isla?
Yes.
Father? Is there any other possible person who could be the father?
No.
And that's your statement under oath that there is no other possible person who could have been the father of Isla?
No.
All right. All right. Any questions you have, Mr. Hahn?
No, thank you, Your Honor.
All right. Well, under the circumstances, I do believe the notice was given as appropriate since there's no other way to get him, and his refusal to even provide an address, which seems awful odd, but his refusal to provide it to the prosecutor so that she could do other types of service. The clear best way then, the only way that was available to the prosecutor's office to serve Mr. Bowden was through email, because he won't let us know where he lives. So she served him proper notice for today's hearing. It was scheduled for 8:30. It's now 9:05. He has never logged in or anything to this. The notice that you sent him, is that similar? All the pages that I have here were sent?
Correct, Your Honor. And it's a notice of a general notice of hearing motion for entry that our office would typically file in a case.
Notice of hearing with remote participation, so that
Correct.
he was given information on how to log into this.
Yes.
And that it was set here today because you intended to enter this at the hearing. It appears that I don't know what else we can do here. Otherwise, he's just going to not cooperate forever, and we're never going to get anything entered. So I do find that he has failed to respond to anything appropriately. There is a box that is checked here that says default and a hearing on the judgment of paternity. Both boxes are, I find that he is in default. He hasn't answered to date, provided no response to this to the court. It's appropriate that I enter the judgment of paternity. I've gone through the child support order. It imputes dad at $25 an hour, and for 40 hours, her income is actual income. As far as potential income for the father, last known employment, previously been employed as a welder, earning $25 at 40 hours a week. At a US-based manufacturer of engineered electric products. Associate's degree is what he has according to the plaintiff. Some of the other factors just are unknown because he won't cooperate with anything. You believe he's available for work. Clearly in Kent County, there is very little unemployment. Minimum wage being $10.33. Don't have any idea if he's even seeking employment, as he won't give any information. So I will enter the child support order also with that as imputed income, since we can't just allow somebody to just not cooperate and not be able to figure out what it is. According to the prosecutor, she tried to get information from him, where he worked, if he made money, whatever, and he just simply will not cooperate. So I'll enter the orders when they are presented to me with DocuSign.
Thank you, Your Honor. I appreciate your time in this matter. I'll have that.
Thank you, Ms. Chavez.
Of course.
You'll get the orders from the prosecutor when they get through. Okay.
Okay. Thank you.
Good luck, everybody. Thank you.
Thank you, Your Honor. Have a great weekend.
You too.
Thank you.
Bye. Neither party has ever logged in. Is that because they're afraid of Miss Rummel?
Know it.
That sounds like it. That's all right. Wood Ellis versus Fowler. This is a date and time set for entering a judgment of paternity and child support order. Neither party has logged in to Zoom. Nobody's here in the courtroom. It's 10 after 9 and it was set for 8:30. Looks like the alleged father here failed to comply with DNA testing. Is that correct?
Yes.
And so basically you're asking for a default, if you will.
Correct.
He was given plenty of notice and many attempts. Did you talk to the defendant, and she's quite certain that, well, not the defendant, to the plaintiff, and she's certain that Mr. Fowler is the father?
Yes.
And she stated that to you unequivocally?
Yes, there was another potential candidate within the conception range that we asked about, and apparently they did a private genetic test. She was not able to provide me with those results, but she said he was excluded, so she was very certain that Mr. Fowler was the father.
All right, you've obviously made many attempts to get in Mr. Fowler to cooperate, and he hasn't. So as far as the judgment of paternity, I'll enter that. The child support order, I believe you have imputed income in there. Let me find it for just a second. You have imputed the plaintiff with $15 an hour times 35 hours. Plaintiff has most recently been employed at $15.50 40 hours in light industry. She has a high school graduate, and it would be appropriate. I mean, Kent County has very low unemployment. The parent is not disabled. It doesn't appear. I think she has one other child, but it does appear that she could work, and that appears to be an appropriate amount. As far as the father now, you say he has previous experience in light industry, a high school graduate, but you know very little about him. I take it he has not cooperated with you at all.
Correct. We have been in contact with him. Actually, bench warrant was issued in March of 2023. The friend of the court bench warrant deputy has been in contact with Mr. Fowler, urged him to come in and complete the genetic testing. He said he would not. He was very certain that we were going to arrest him and put him in jail. Caseworker with our office has been in contact with him several times. We offered to meet him outside the office to collect his sample. Again, he said, no, we were just going to arrest him. He wasn't going to participate. So we have been talking with him. He hasn't provided a lot of information about himself, but I do believe that the statements I made in the imputation portion of the Uniform Child Support Order are accurate.
Well, it appears you're really giving him a break, quite frankly, because you got him a minimum wage at 35 hours. And quite frankly, almost anybody around here can get a job for $14 an hour at McDonald's if they need to. So I think you're being generous and towards him. So I will at this point enter the paternity order and the child support order, even though I think he's being imputed a little bit low, if that's what you're asking for, and the plaintiff is not here to object to anything like that. I'll enter that order. All right.
Okay, and then there's also, I need to submit an ex parte order to discharge the bench warrant once the judgment of paternity is signed. Would you like me to submit that with the documents or after?
That's to discharge the bench warrant, but you can, but I'll have to make sure because the bench warrant was issued, I'm sure, by Judge Hillary.
Yes.
And I really
Only
think
he
you
can
could
discharge
enter
it.
that with him. He should
Yeah.
discharge the bench warrant, not me, because I didn't authorize it to begin with. Okay. But we'll
Okay.
probably get it to Judge Hillary after I sign these orders.
Sounds good. Thank
All
you.
right. Good luck. Thank you. Have a good weekend.
I'll see you later, I believe, at 9:30.
Oh, all right. You're back. Matter of
Bye-bye.
Ramos. Is there another one coming up? Cano versus Valley. We have the prosecutor's office represented here by Ms. Brower. We have the defendant, Mr. Valley, represented by Ms. Grauman. This is for entry of a judgment of support. As I say, the plaintiff has never logged in. This is the request from Ms. Brower. Do you wish to? I've read Ms. Grauman's request as to why it's unfair, but the entry of the child support. Do you have any response to that?
I do, Your Honor. I am asking that the court enter the proposed judgment as well as the UCSO. A deviation is not warranted. The fact of the matter is that the defendant is more than capable of earning $14 an hour at 35 hours per week. In Michigan, when reviewing the imputation factors, the child does not deserve less just because the child lives in Mexico, and especially when the imputation is very reasonable. MCL 552.2303 states that the responding tribunal of this state shall do both of the following, which is A, apply the procedural and substantial law generally applicable to similar proceedings originating in this state, and also may exercise all powers and provide all remedies available in those proceedings and determine the duty of support and the amount payable in accordance with the law in the support guidelines of this state. Considering the exchange rate for determining child support would not benefit the child, it would only benefit the defendant, who is more than capable of paying what is recommended. If the exchange rate is considered, that would mean the equivalent of penalizing the child for where he lives. The court in Tarrant versus Ritland, the site is 313 Mishap 197, was also posed with a similar issue. I want to say really the exact same issue, and held that the trial court may not, as a general rule, deviate from the Michigan child support formula recommended child support on the basis of any differences between the general cost of living where the parents and the child resides. So for those reasons, I am asking that the court enter the proposed judgment as well as the UCSO. Before I forget it, just as a matter of housekeeping, I accidentally, on the proposed judgment of support and the UCSO, in the heading, I hand wrote the state of Michigan ex-rel, but that should not have been written in there, for the reason that this is a UE case, an interstate case. So any judgment that gets submitted to the court, I would make sure that that is not on there. And the second thing is, I forgot to put the defendant's attorney's name and her contact information in the heading on the proposed judgment and the UCSO as well. I will also make sure that those get included. if and when a proposed judgment in UCSO do get entered.
All right, thank you. As to those additions, whatever they may be, or subtractions, you don't have any objection to those, do you, Ms. Grauman?
No, I don't have any objection to those specific additions.
All right, so I've read your objection. Anything you want to add?
Well, what I would add is, I mean, even thinking about when the court imputes income to defendants, that, like, let's say we have a defendant that lives in Kentucky. Are we going to do the minimum wage as of Michigan, or are we going to do the minimum wage?
Lives in Michigan, so I impute him as of Michigan right now. He doesn't live in Kentucky. And my real question to you is, okay, what if his child lived in, I think Switzerland has an extremely high cost of living. Would you say that your client would pay more than this because it represents very little income to them over there?
I guess the problem I have is the amount of, because of the drastic differences of income, it is literally going to be a windfall for her. It's essentially unfair that he's essentially paying more than he should be paying.
He's paying according to the child support guidelines, okay?
Right.
And it's not according to what she receives. It's like I say, the same sort of thing. What if the child lived in a place where the cost of living was much higher than here? Would you say that I should make his payments significantly more? Certainly not. You wouldn't. I should take 50% of his income because they live in an extremely high cost of living area.
I understand looking at it from that perspective.
Well, that's what's good for the goose is good for the gander.
But yes, but at the same time, I mean, this is the amount of money it's literally going to be, I mean, the difference between, it's literally going to, it could put her in essentially a luxury apartment, and it's giving her
and your client objects to his child living in a luxury apartment?
I think he objects
to maintain the standard of living.
That's not the issue. I think the issue is the windfall for her. That is the issue. It's not fair.
Right. You've forgotten, this is child support, not mother support. It is child support. And if the standard of living for the child raises some because of that, that's good. It's his child. So quite frankly, I don't find any validity to the argument because she lives in Mexico and the cost of living is significantly less down there. Like I say, I know you wouldn't be here if it was meant that he had to pay a lot more because the cost of living in other places is higher than here. So I think that under the circumstance, and there has been, you didn't object to the imputation, as he thinks he should have to pay. I think the imputation is clearly reasonable, and there was no objection to that by counsel. So I'll enter the orders.
Sounds good, Your Honor. I will have this sent to you via DocuSign.
All right. Thank you all very much.
Yes, have a great weekend.
Same to you. Number 9? Was this number 9? It's on the Beatles' White Album. You ever listen to it? Well, I guess I'll have to play that for you. It's a classic. Then you'll start. Good morning. We're here in the matter of Emmert versus D. Piazza. Both parties are present with their respective attorneys. Mr. Hess represents Mr. Emmert. Miss, I hope I get it right, Tarasi?
That's fine. Yep.
That's fine, or it's right?
It's right. It's okay. Yep.
Mr. Rossi is here representing Miss D. Piazza. It's a motion brought by plaintiff father for custody change. Mr. Hess brought this motion. Mr. Hess, I've read your amended custody request. What do you want to say about it?
Thank you, Your Honor. I will highlight the changes in circumstances which have occurred since the last court order of 2017. I do think that the custodial environment has changed. I'll say that where my client has had, the defendant mother has had, she had no overnights at all from late 2022 until very late 2023. And since then, she exercised only alternate weekends, Friday and Saturday overnight for most of 2024. She indicated on April 28th she was going to go back to start exercising the 2017 court order, and my client quickly filed with the court. I think the initial hearing was set for May 31. He decided shortly before that he should have counsel, and it was necessary to adjourn things until today. I think that's one big change that's gone on. There are also believed to be, or in fact known to be, 7 to 8 people living in a very small 2-bedroom house with 6 of them in a cramped upstairs. And my client knows this information from the defendant, her husband Blake, and the children. He did look up the building code, and it looks like there's only 234 square feet up in the upper floor where the defendant and a number of people are staying. It looks like 6 total people and 234 square feet. There is a Kent County standard that says that each person should have 100 square feet of habitable floor area for each occupant. So it certainly appears that that's not being complied with. There's drinking and domestic violence issues that have occurred over in the defendant's household between her and her husband. There's a couple of police reports we attached from late 2022. I'll quote one of them. Hillary stated her husband, Blake, had been drinking for most of the day. Hillary explained when he drinks, he gets aggressive and was scaring the children. Hillary stated he did not get physical.
I'll stop you with that. I mean, that's 2022. That's not very fresh information. Go ahead.
Sure. But the overnight stopped for Hillary very quickly after that.
Where are the kids? Where are they enrolled in school?
They're enrolled at Tri-Unity Christian schools.
And does either party live in that district?
They don't have a set district because it's a private school, so they get dropped off and picked up.
All right. Because it's my understanding, didn't she live up north somewhere for a while, but then the kids came down and came back to Tri-Unity, as I recall?
Yes, they both have moved numerous times, yes.
Yeah. But the kids used to attend Tri-Unity before they moved?
Yes.
Before Miss DiPiazza moved the kids up north, they attended Tri-Unity, and then, as I recall, maybe I'm wrong, but I think they came back to Tri-Unity.
That's correct.
All right. And how far do you live from Tri-Unity?
I live 12 minutes from Tri-Unity.
All right. And your client, Miss Terassi, ma'am, how far do you live? You live down in Wyoming, right?
Yeah, I live it's about 6 minutes.
6 minutes?
Yes, sir.
Where is Tri-Unity located?
Granville.
54th and Wilson.
All right. Okay. Go ahead. I didn't mean to interrupt. I was just curious about where they were going to school and want to make sure they keep.
Sure. Your Honor. So the Hillary is saying that the kids and her were afraid of Blake. She's telling my client and my client's mother that the children are afraid of Blake when he drinks. It looks like there's all kinds of instability and chaos with her relationship with Blake, and that the children are scared. Their clear preference that they're telling to my client, and this is why, largely why
that's up to me to decide it.
I understand that Your Honor wouldn't know that until you talk to the kids, and I certainly understand that the case law is pretty clear that the children's preference alone is not sufficient. But it is a factor. It does relate to the factor with all this other stuff going on. It's certainly more than plausible that the children's preference would be to remain in my client's primary care, where they have been living since late 2022. So I do think that there's a number of changes of circumstances. There's also the fact that my client has done school, done most of the school and medical, had most of the involvement with that since 2017. And now all of a sudden, over the past few months, the defendant is scheduling all kinds of appointments for the kids with a questionable basis at best. So I do think that there's all kinds of changes of circumstances as I've laid out. So I think that the initial threshold has been met. I mean, the kids were in my client's primary care for a year and a half. until April 28th, and then my client quickly filed an action at that point when she says, well, I'm going to exercise my court-ordered parenting time from 2017, despite all these changes that have occurred since then. So I think with that, further proceedings should be set, whether it's a friend of the court, going to the front of the court, or an evidentiary hearing. But I do think that we've met the threshold. Thank you, Your Honor.
Thank you, Ms. Teresa.
Yes, Your Honor. I don't believe they've met the threshold at all. He's talking about changes since 2017. That was 6 years ago at best, maybe 7. You can't now come back in 2024 and say something happened in 2019 or 2021. He's been allowing the parenting time. He could have came in an emergency basis and said something's wrong.
What about the fact that the kids did primarily live with him for a period of time when she was up north? And I mean, it's pretty clear that at one point, for at least over a year, the kids lived primarily with him. They haven't been following the schedule.
It is, but neither one of them have been following the schedule, and they have both been going back and forth. Mr. Emmert was kicked out of his home, and they all had to move to grandmother's house. So, I mean, at one point, Mr. Emmert was kicked out of his marital home and had to go live with grandmother. There's been constant back and forth for these 5 years between the parties.
All right.
So, but no one's filed anything saying, hey, mom moved. We need to change everything.
He did now. He's said
I know, but it's 3 years too late. Nothing's happened in the last year.
Because the kids have been primarily living with him until April of this year.
Okay, well, we dispute everything that's in the complaint, but I want to point out some main things that are untrue. And he is saying all these things are wrong with Mr. Piazza, but he didn't inform the court. Well, the court probably knows about the domestic violence. He's had 3 OWIs. He was arrested while the children were in the car with him. So there's all these.
When was that?
2022.
Okay.
It was his 3rd OWI offense, and he was arrested with the children.
I didn't hear that, but don't talk. Anyhow, I didn't hear what you said, sir, but do not answer.
There's numerous things they bring up about Mr. DiPiazza with his father, his parenting. There's all the CPS charges were released. He was awarded the children. There was a whole big issue with that, but all of it was resolved. He didn't get nothing was wrong, nothing in trouble. The housing, mother lives in the top of her mother's home. It is a 2-bedroom, but they have the whole upstairs, and it's been remodeled, and it has, I have pictures. I want to see it. It has built-in queen-size beds for each of them. There is a kitchenette, there's a shower, there's a bathroom, there's a toddler room for the toddler that has playroom and a bed. There's a dresser, TVs, there's everything up there. They have the whole, it's the whole length of the house, and they are allowed to go wherever they want in the house, but they really have everything they need up there. They even do their cooking up there. They have a kitchenette with an air fryer, microwave, refrigerator, everything that they would need. So there is nothing appropriate with the housing.
Custody here today. My concern is that I understand they have not always abided by it. They've done what normal parents should do, and that they've accommodated each other when there have been difficulties. However, the fact that the kids have lived with him primarily, with only your client having like every other weekend, basically, for a significant period of time, right up till basically the motion was filed, is a change of circumstance, because that was not what was in the original order that they were doing. And I think it's a change of circumstance that he has had the children most of the time for the last year and a half. There's going to be plenty of time that we can argue about all kinds of stuff as far as whether her living arrangements are appropriate or not. And that would be something that, the home environment, the length of the time the children have lived in a stable, satisfactory environment, and the desirability of maintaining continuity, whether or not that's appropriate or not. That's probably a proper cause question. All I'm finding here today is that I believe there is preliminarily proper cause or change of circumstance, as I have stated, to have an evidentiary hearing. Now, Mr. Hess at that hearing will be responsible to prove that there's been a proper cause or change of circumstance, because I don't have what I consider evidence, proof here now. This is just an offer of proof, if you will. And that'll be the first thing that he'll have to prove at any custody hearing. Because to proceed on, I don't bifurcate it necessarily. We'll just go ahead with it. And if he doesn't show that there is proper cause of change of circumstance, I'll never get to the other parts of my hearing, such as established custodial environment, best interest factors, and all those sort of things. But I think there are enough allegations here that it's clear that we should have an evidentiary hearing. Mr. Hess, you've said whether or not I should send it to the friend of the court or not. Quite honestly, I can send it if both parties want, but what are the odds that if the friend of the court says something like Miss DiPiazza shouldn't get joint custody and it should go to him, that she's going to say, okay. And the same to you, Mr. Hess, if they say, nope, we should, go back to the old ways or something like that, that your client's going to agree to it. And that will add 3 months, and then we'll have 3 months beyond that before you'll have your next hearing. You're not going to get a hearing until probably September as it is. But if both parties really want me to send it there because they think it can be resolved, that's fine. The other possibility is both parties could do mediation and see if they can resolve it. But I'm going to leave that up to you. I think I should just set an evidentiary hearing as opposed to going to the friend of the court. Any thoughts on that? Miss Tarazi seems to be shaking her head. Yes. Let's just tee it up.
Mostly because I see your point. It's going to just stall it. And
it's going to stall it. Yep. We're going to, Mr. Hess?
That's fine, Your Honor. I was basically leaving that to your discretion.
All right. Thank you. You thought I would be able to have discretion? All right. Then let's set up, my clerk will get to both of you, the two attorneys, to find an appropriate date. We'll also have some kind of a pretrial settlement or whatever you want to call it sometime before then. As you know, my orders include things like when you have to exchange exhibits and things like that. I want it once we go to go smoothly. I use this as an example. If there are police reports and stuff, you guys can kind of agree that you don't have to bring in the policeman, okay, for foundation unless you really think you need to. All right. Because my experience is if you got a police report from a year and a half ago, the officer is just going to read the report and have nothing more to say to it other than that. So I want you to work together to try and make sure that we make this go as smooth as possible. We'll meet ahead of time to see if there are any evidentiary issues, probably a week or so ahead of time. Anything else I should address at this point? No.
I don't believe so.
All right. We'll be in touch with both attorneys to try and make it work with your schedule. As I say, it'll probably be September, maybe even early October before we have it. Be prepared to be limited in time. I don't want this to go on forever. Once we start it, get to the point and let's figure it out. All right.
Okay.
All right. Thank you, Your Honor.
Thank you. Good luck, everybody. Take care. Have a good weekend.
Thank you too.
Really want to watch Miss Ballast and Miss Wolfram.
Morning.
Morning.
Is Melanie with?
I
Is
think
Melanie with you, Miss?
no, she was going to sign in when I let her know, but I didn't know if she has to step out of work in order to do this. So I didn't know if her presence was required since we had.
That's up to you. I'm not going to require her presence if you say you can do this without her.
I believe I can.
All right. Do I have, the clerk has informed me of good news and that the parties have reached some kind of an agreement?
This morning, I heard from Ms. Wolfram that her client had agreed to the proposed order. She drafted a alternate proposed order, which my client will also agree to with some further clarifications. I haven't been able to follow up with him on what those clarifications were, but I think we do have a resolution on this motion.
Ms. Wolfram, I mean, because none of this do I have any idea what you guys are agreeing to. So you're asking me to enter an order and I have no idea what any agreement.
Just do a little bit of a clarification, I guess. Ultimately, the parties really did not have any, like that they were sort of doing parenting time as agreed. And you had referred to friend of the court for a more specific schedule, but these folks live, dad lives out of state. So there's kind of limited amounts. So they just needed to get some clarification on, there's probably never going to be a strict parenting time schedule like there is for cases where parents are local. So we were able to narrow down the parameters for the parties, nail down exchange locations and, agreed upon grace periods for allowing for travel and things like that. So that's what our agreement is.
Well, I hope that you guys can enter a stipulated order because, again, there's nothing on the record to even enforce. I mean, Ms. Ballas, you come in and want me to enforce an order, and there's nothing that I have nothing to enforce unless there is written agreements between the two of you. So I
understand.
I will wait and get your stipulated order. You could renotice this, but I don't know why, because like I said,
prefer not to renotice it.
there is nothing that I would be able to enter. So I hope you guys can agree on whatever is necessary and that I will see you only on other matters.
All right, thank you.
All right, good luck. Thank you. Thank you,
Yeah.
Mr. Gordon.
Thank you, sir.
We're adjourned. Pick up speed from here on out.
Number one.
All right. It is originally Ardema versus Waite. The plaintiff's name is now different. There's a motion by the plaintiff mother. Says there's been a change of circumstance regarding child support, that previously the parties were doing 50-50, that the child who is Emma, who is 15, spends most, if not all, nights. Let's see, Emma does not spend nights at her father's anymore and just wishes to have the friend of the court review the uniform child support order. The last one was from 5/30/23. Is that in essence what you were asking for, ma'am?
Yes.
Mr. Waite, what's your response?
Yeah, I'm okay with, I would like to go back to having her back like as the original 2 days a week and every other weekend. I'm totally fine with that. I mean, if that's what we can do.
Well, it doesn't appear. I mean, there's a change of circumstance for the friend of the court to review child support at this point, because you don't deny that the child doesn't spend the nights with you, and I'll send
No,
it to
sorry.
the court. Now, I don't know what's happening with the other part. This is not a motion for you or a motion or an order to show cause or something that you have said that Ms. Voorhees is keeping the child from you or something like that. It's just in this case, clearly, they're not the same number of overnights that were in the uniform child support order of May 30, 2023. So I'm just going to send it to the friend of the court for them to review it. Whatever else happens in this matter, it'll be left to whatever else happens. All right?
All right, Your Honor.
Both of you can talk to the friend of the court about overnights or whatever. Good luck. All right, I'll just send it to the friend of the court. There is no cost to you. They will make a determination. Make sure you follow whatever it is that they say if you're going to object to it. All right? Because they'll issue a recommendation, and if you're going to object, you better do that in a timely manner, either of you. Okay? You understand that, ma'am?
Okay.
All right, good luck. We'll send it to the friend of the court. Take care. Have a good day.
You too.
Thank you.
7-DM. Both parties are present via Zoom. This is a motion made by the mother regarding parenting time. She wants what?
What?
She wants parenting time reduced or supervised. Says dad doesn't appropriately feed the child.
Yes, I do.
Man, sir, don't interrupt me, all right?
Okay,
I'll
sorry.
give you your chance.
Okay.
Says does not appropriately, says the child's on meds, and after visiting the father and stuff, meds keep having to be increased because of her apparent anxiety or whatever it is that needs increase in meds. His boys come into the bedroom where Jessica, who is 13, is sleeping at night in her own room, and what it says is that father says, well, they have night terrors and they just go in there for comfort. CPS has been to his house, but I don't see anything that has been substantiated, ma'am. And she also indicates that dad never goes to doctor's appointments and stuff. Anything else you want to say, ma'am?
Yes, my daughter's health is at risk. Her mental state's at risk. I mean, I'm afraid that if she continues to go to dad's, it's just going to get worse. And then her meds are going to get increased, and she might end up in Pine Rest. The psychiatrist already offered her to be in Pine Rest.
Do you have anything from any of those people any statements from anybody?
No. They wouldn't give it to me.
Why wouldn't they give it to you?
They said they would give it to a CPS worker.
Well, did they give it to a CPS worker?
I have no idea, Your Honor. I know they have talked to them.
You know that they have talked to CPS?
Yes.
But
her counselor and psychiatrist.
But apparently CPS is not involved in the case.
Right. They've been called many times to his house within a 40-day period.
But, I mean, that doesn't tell me anything. Okay, I mean, because unless they substantiate something, it just tells me that they've been called to the house, just like if they were called to the house because they thought you were a thief, and people keep saying that, but they keep coming there and finding nothing.
Yes, they said there's food in their house, but there's no evidence that they're not feeding her. But my daughter comes home starving and eats 5 helpings of food and 3 cups of milk at a time, and she does this for 2 days. My child is scared to death to eat sometimes. She had a panic attack right in the middle of McDonald's when I asked her what she wanted to eat after coming back from her dad's.
How do I know this is all related to the dad and not some other issues?
Because it's just coming back from dad's, this is happening.
All right.
Even the school said this.
Well, why didn't anybody provide any substantiation for this?
I've asked the school to give me information. They said they gave it to CPS.
Well, what have you talked to about CPS? Who have you talked to there?
They said that they couldn't give me any information until it goes to court.
All right. Well, then maybe I shouldn't do anything until it goes to court.
This is the court we're talking about, Your Honor. It's because when I take him to court.
And then CPS is going to get involved with it?
No. They said they wouldn't do anything until you asked for the information.
Until I ask for the information?
Yes.
I deal with CPS a lot, and that doesn't make any sense to me.
Well, that's what I got told.
Sir, what's your response?
She does eat. I told Jessica every time she comes over, she can eat what she wants in the house. And I don't know where Stephanie's getting this from, because I missed my daughter for two and a half months. I hadn't seen her for 2.5 months because of
Have
her.
you filed any complaints with the friend of the court?
Yes.
All right, and that'll come before me.
And there's nothing going on in my house. All my boys, because they're afraid of the dark, they come to mom or dad when they need to, or if Sissy's there, they try to talk to Sissy.
Well,
and there's food in the house and everything.
First place, you got to put some kind of something on her room to prevent those kids from going in there.
Yeah, I do. I tell them to stay out of there.
Well, you tell them to stay out of there, but they apparently don't.
They don't want to stay out, and I tell them not to.
What?
I tell them not to go in there, and they still go in there. And I don't know why they still go in there, right? And I told them,
but that's up to you to do that. That's up to you to keep them out of there. Put a lock on her door.
Okay.
Or do something. I mean, why would I have to suggest that?
No, I think I can do that. I can do it on my own. I know how to do it.
That doesn't.
And I'm letting you guys know, there's a lot of food in my house, and I've been going to a counselor again, because of stuff going on. And
what stuff's going on?
I have anxiety attacks in my sleep.
Okay.
Now, my doctor's prescribed me to go back to the counselor again.
All right. Well, in order for me to have some kind of a hearing regarding parenting time, I have to find what's in a case called shade, which is kind of proper cause of change of circumstance on a much lower basis. I think what I'm going to do is I'm going to refer this matter to the friend of the court for them to evaluate parenting time. I'm guessing that you probably both can't afford the $150, so I'll waive the fees to send it there. Ma'am, you can bring all your stuff up in front of the friend of the court, whatever it is, whatever proof you got. You're going to have to get some proof, right? Because you just saying this stuff, it's not like I say, not like I don't believe you, but I got to have some kind of proof.
I have her my chart from her psychiatrist proving all this too.
All this what?
All this of what's going on with dad and why she's acting out, having anxiety attacks, panic attacks because of dad. And she does this just coming back from dad. And she's even stated this to the counselor and the psychiatrist. She's scared to go back.
I got to have some kind of proof. All right. And I don't have it. So I'm sending it to the friend of the court for evaluation. In the meantime, sir, I think I'm going to change your parenting time. Ma'am, I'm not going to have your daughter spend nights there right now. All right. I think it'd be appropriate that she can visit with dad, from 10 a.m. every Saturday till 7 p.m. She's not going to starve during that time and things like that, but I want her to continue to see dad, all right? And we'll figure it out from there. All right. So I'm going to enter a temporary order that says time from Saturdays at 10 a.m. till Saturday at 7 p.m. every Saturday. So she continues to see dad, but she's not going to spend nights right now. We'll figure out what's going on after you meet with the friend of the court.
Does it start tomorrow, Saturday?
Is there a problem with it starting tomorrow? Otherwise, we can start it a week from now.
We can start a week from now.
All right. Start a week from now, but I expect you to follow through on that order because she's not going to be there. She's only going to be there 9 hours. All right.
Okay.
She's not going to starve during that time, even if she doesn't eat. All right. You can
Right.
feed her before she goes. So,
yes,
sir, starting next week, Saturday, 9 a.m. 7 p.m. We're going to do the
I don't know why.
friend of the court.
And I don't know why she says that to start. She doesn't. And I don't know why. It's my daughter, and I'm kind of frustrated with it.
I'm telling you right now, you start next Saturday, 10 till 7. We're going to get to the bottom of it. You're going to be able to go to the friend of the court, tell your side of the story, provide everything. Mom will go there. We'll try and reach some kind of agreement through the friend of the court. It's going to be referred for parenting time. Good luck. All right.
Thank you, Your Honor.
I'm going to waive the fees. Good luck. Thank you.
Thank you.
Yes. McSaube versus Fox. We have both parties present via Zoom, as well as a representative from the Kent County Prosecutor's Office, being Ms. Rummel. This is father's request for determination of paternity on a child who is 2. I'm not sure how I pronounce the name of the child, but child's 2. There's a judgment of support that was entered on 6/3/24 regarding that child. Father is asking for a DNA test and a ROPA. I know at one point before, mother asked for a ROPA motion for DNA testing, but it was for a different child. So then that was denied. Miss Rummel, do you enter into this anywhere?
No, Your Honor, I'm just here in case the court is inclined to order genetic testing through the prosecutor's office.
All right, thank you. Mr. Fox, you think you're not the father of Mingan?
Mingan? No, I am not the father.
Ma'am, you think he's not the father?
Yes, he's definitely not the father.
Well, then why don't we do a quick DNA test? The prosecutor here is here present, and we can do that through the prosecutor's office. Make sure you cooperate once. If it comes back the way I anticipate it will, is that shows that he's not the father, we'll deal with it at that point and probably take him off of being the father. All right. Mr. Fox, you can cooperate with DNA?
Yes, Your Honor.
And Miss McSaube, you're going to have to make sure that the child is there and stuff like that so we can get DNA.
Yes, of course.
All right, Miss, we'll enter the order for DNA testing, but Miss Rummel, what, they can do it through your office or what?
Yeah, we can generate the DNA test orders as well.
All right, thank you very much. We'll get an order out there. Make sure you cooperate with DNA testing, and we'll get to the bottom of this soon, okay?
Okay, thank you, Your Honor.
Thank you. Thank you to everybody. Thank you, Miss Rummel.
All right, have a good weekend. Thank you.
You too.
Have a good weekend.
Thank
Thank
you.
you so much.
Is Mr. Hunter connected?
Yes.
Mr. Hunter?
He's at my office and I'm at home, so I'm gonna make sure he gets on video here.
All right. That's unusual. You're at home and he's at your office. Usually it'd be the other way around. I'm sorry. But... so as I said, this is Hunter versus Otero. I think both parties are present via Zoom, but we certainly have their 2 attorneys present, that being Mr. Toburin representing the defendant, Mr. Hunter, Mr. Danian representing the plaintiff, Ms. Otero. This is Ms. Otero's motion for parenting time. Looks like back there was a stipulation in order for custody, whatnot. Dad has legal and physical custody, parenting time as agreed. Mr. Toburin, your client still isn't connected, apparently. Do you want me to wait for him?
If I can go on mute for 1 second, I'll call my assistant.
All right. Mr. Danian, you're sitting there very calm and collected.
Good morning.
Good morning. Nice to see you. Haven't seen you in a while.
You too. Thank you.
Thought maybe you'd retired, moved down to the Caribbean for a while.
Not so lucky.
All right. Now we have Mr. Hunter. Mr. Hunter, can you hear us?
Yeah, I can hear you.
All right. Everybody's present now. I've already stated this is mother's request for some type of specific parenting time. She has stated that she has apparently moved down to North Carolina where her husband is stationed in the military. And the only thing in the order that we have as parenting time is as agreed. When requested, I have to set some kind of specific parenting time because otherwise it's just not enforceable. She wants certain times, obviously in the summer, Christmas, spring break, that kind of stuff. Mr. Damian, that's what you've requested, right?
Exactly. She just wants a parenting time plan where she can still see her daughter on a regular basis and maintain a good relationship with her.
All right. Mr. Toburin, your response? I mean, I have to set specific parenting time at this point.
Yeah, my client does not agree with that proposal, and he does not, I think for good reason, does not want the child going to North Carolina right now. My client is concerned about violence in the home between Ms. Otero and her new husband. So apparently Ms. Otero and her husband have a older child from when they were dating prior. Last year, she told my client that she was requesting a PPO against the man who is now her husband. They've done FaceTime since she moved, and my client has seen and heard the husband yelling at Ms. Otero and the child, and she's even told my client that she's concerned about her husband's behavior since they moved. And I would also say that before she moved, her parenting time by her choice was somewhat limited. As the court mentioned, I think Mr. Danian's motion even noted, my client has sole legal and physical custody. That's because Ms. Otero has had some struggles with her mental health, including bipolar disorder.
Mr. Tobirin, are you suggesting she gets no parenting time?
No, and not at all. He would like it right now to be in Michigan. He's not comfortable sending a 2-year-old to North Carolina when she's telling him that she is, and he's witnessed through the FaceTime that he's concerned about violence in the home and prior mental health issues that led to him having sole legal. So he would and has and would continue to support the FaceTime visits. And if she comes back to Michigan, he's more than willing to make the child available to her, but to send this child to North Carolina right now, he is totally opposed to.
Well, Mr. Danian, I mean, I'm watching your client shake her head no to all kinds of stuff.
Right. I guess this is, something that we had not heard previously. I think, it's an issue where my client, I think, has even been denied parenting time now that she's requested these past couple months. She hasn't even seen her daughter, I don't think, for quite some time now. We need to get something started. If there are legitimate concerns or if they want a background check, I mean, we need something verifiable because there's nothing else that I've even seen that comes close to what they're alleging.
Well, I think it's verifiable when he has sole legal.
How am I supposed to, she says, I don't have domestic violence in the house and I just want to see my kid. And you say, it's full of domestic violence and she's got mental health issues. And what mental health? I mean, do I have anything? I got to have something. I mean, he points at her and she points at him.
Well, I agree. I think when the fact that he has sole legal is based on these concerns.
I understand he has sole legal and physical as of, I think it was just December of this last year, 6 months ago. Okay.
Right.
But there was also parenting time as agreed. And obviously your client's not going to agree to any parenting time. So she has to come in. She has to come in and ask for it. I can't proceed with a parenting time as agreed when they can't reach an agreement, right?
Except that my client had, from what he has told me, and I would tell you, I was hired very recently. My client did not receive the motion, and I know Mr. Danian mailed it to him, so somehow it did not get to him. so we didn't know exactly what their request was until yesterday, but he tells me that before she moved, he was not denying her parenting time. They were meeting at the park and they were doing FaceTime, and they've done FaceTime
But
since.
he's denying it now. So I mean,
He's not denying parenting time. He doesn't think it's safe for this child to go to North Carolina.
She's just got to drive back to Michigan to get it.
Well, I think that has to happen either way, whether she's doing parenting time in North Carolina or here. Someone's going to have to travel with this child.
Yep.
So I don't think it's a burden for her to come here.
It's maybe not a burden for her to come here, but she doesn't live here. Okay. I mean, she doesn't live here. What, do you want her to stay in Motel 6 for 3 weeks?
And I don't know if she has family local or not. So I don't know the answer to that question.
That doesn't necessarily mean that she can come back and live at her family's for 6 weeks or whatever. I mean, I got to get to the bottom of this somehow. And I need some type of evidence, if you will. I'm not denying what your client says, but I'm also not denying what Ms. Otero says. I don't have anything like that. He says she's bad and she says, no, I'm not. You tell me a solution.
Well, like I said, our proposal is that she come to Michigan and do her parenting time. No.
Yeah, I don't think that's realistic or reasonable, Your Honor.
It's not realistic because I have no idea if she can come here and, like I say, she has to come here and stay at the Holiday Inn for 2 weeks while she has her child. Does he want to pay for that?
She has family that lives here.
I don't know if she can just take a 2-year-old child, live at their families.
Because she was staying with her sister before she moved.
Can I say something?
I don't know, Mr. Danian.
I guess, yeah, go ahead real quick.
So me and Fred did come to some agreement. So this is all new to me. I have cancer, so I'm in treatment, and my thing is to finish treatment here. I have 7 treatments left, and then go down there and get my daughter and bring her here. This is a total safe environment. We live in a community, so I'm not sure where the violence he's saying is coming from. There's no violence, domestic or nothing like that. My mental health deteriorated when me and Fred were together. I'm completely fine. I can be evaluated. Anything you need me to be, sir. Anything so I can prove that I'm a fit mother. I'm raising my 4-year-old son as well. So I'm in a great shape in my life right now.
And you're undergoing cancer treatments there?
Correct.
In North Carolina?
Yes, sir.
Are they like chemo? Or, I mean, I'm not trying to get very far into your personal life.
I'm chemo every week. I have chemo every week.
Well, so then that makes it unreasonable, Mr. Tobirin, for her to have to come up here. Mr. Tobirin, Mr. Hunter wants to say something now.
Yeah, all this is kind of new because she was doing her treatments down here when she was here a couple months ago when she first told me about her cancer situation. So then she wants to move to North Carolina 3 months later. So it kind of just put our daughter in a bad position where she lives with me. Her family's here on both sides, from her mother and my side of the family. So now she wants to move to, well, she's in North Carolina now. So now she wants to do traveling back and forth with our daughter. And I just don't really want the inconsistency really and whatnot. It's kind of a hassle for our daughter and whatnot. And as for her mental health, I don't really know how her mental health is. I just know
the hassle for your daughter. Your daughter's got to know her mother and her father.
Which I do, which I believe. I want her to. Yeah.
And she's got to spend time with her mother and her father. And obviously a majority of the time is going to be with you, even if I granted all of the time they ask for, which I probably wouldn't, but even if I granted it all, you'd still have a vast majority of it.
I want her to see her mother. I do. I don't want her to not see her mother. It just right now she just moved to North Carolina and it's also rushed and whatnot. So I kind of want to at least get.
But it's because she can't see her daughter, and she's got to make a motion because you guys can't figure anything else. Let me ask you this, Mr. Tobirin, Mr. Danian, what about if I adjourn this for 2 weeks and you guys talked about something reasonable? You know where I'm going to go. I've got to get mom some time. All right. And it's not, I mean, I would be a lot more worried if the child was in school because I'd have to deal with the summer. All right. But the child is only 2. And if for the next little bit of time, if she were to go, even if I said she's going to get her for 5 weeks or something like that, if I gave her to her 5 weeks in September, it's not happening. We're not interfering with school.
Right.
And I've got to get her some time. I've got to get her some specific times. You guys need to work on it. Do you think that the two of you two who I generally consider, well, I consider one of you to be reasonable. You just got to figure out which one. And can you can you work on it? And if you can't come up with something, come back in 2 weeks and I'll have to make some kind of decision or.
That's fine. My only,
what?
That's fine, but I'm not available on the 12th due to a delinquency trial, so it'd have to be the 26th.
I mean, again, I'm not as worried right now. I want Mr. Hunter, I want her to have at least a couple times a week FaceTime. All right,
Yeah,
right now. And
I think she has been.
And ma'am, I'm going to get you some parent. What'd you say?
I think she has been doing FaceTime.
Well,
It's whenever Mr. Fred feels like it. He ignores my calls and texts and
all right. Well,
yeah.
then if I need to set up a Mr. Toburin, Mr. Danian, you know what the court is going to order on that. At least a couple times a week, set specific times. All right. I don't. We'll adjourn this for 4 weeks. Expect that you're going to come up with some kind of an agreement. She's going to have time with her daughter, and probably time in North Carolina. I'm telling you, I'm not. If she's on cancer treatments and whatnot, you can't just say, "Yeah, I'll move him back up to Michigan for 3 weeks and then move him back down there." Mr. Danian, you should be able to prove some of these things, and to Mr. Toburin, as I say, one of you is really reasonable, and the other one's going to have to become so. All right.
Do we have to renotice it for the 26th, or is that automatic?
Can we?
That's what I was giving him.
Yeah. Oh, my clerk is giving me a note says have them renotice it.
Okay.
And at this point, she's the ruler of the roost. So
very well,
as you well know,
for good reason.
So if nothing happens between now and the 26th or whatever the next time is that we can get together, I gotta get her some time. So with those marching orders, let's work on it. And both of you better see to it that she gets at least 2 FaceTimes a week right now. All right, at least 2. Right?
Thank you.
And the unreasonable person is, if I find out one or the other is not being reasonable, it's not going to go good for that person. I'm happy that both of you are on it. I know you can. I know you know what I'm saying. All right. So I know you can figure something out. If you can't, we'll see you in 4 weeks. Just send through a renotice. That's it.
All right. Sounds good. Thank you.
Thank you, everybody. Take care.
Thank you.
Good
Thank you.
Thank you. Is this the last one? Number what? Has no problem lying right to me. All right. This is a motion brought by Fowler for DNA testing, if you will. Is asking for DNA testing of the child in this case. Anything you wish to say, ma'am?
No,
You don't oppose the DNA testing, I'm sure.
no, I didn't want the DNA test, but we can do it. Well, I mean, the other judge already had put in the order for it to be done, and he didn't go do it. He got the case dismissed.
No, I didn't get the case dismissed. I didn't know I had a court date, and I had just lost my job at the time.
Oh, look at that.
Pay for it.
It clearly there was a prior order, and for some reason,
I'm the one that filed it.
I understand. I'm not, look at you're arguing with somebody you don't want to argue with right now.
I'm not arguing with you, sir.
I'm just telling you there was a prior order for it. Apparently, for whatever reason, it was not done. The case was set aside, but you filed another motion.
And
Hold on. You filed a motion to reopen it. The court did reopen it. And we need to get a DNA test now.
I already got the DNA test done, sir. I got it done the same day that they took her from me.
All right, for you and the child?
No, she had the child now in her custody. The child been with me for 3 years now. She got her. They took her from me.
Well,
She was with you for 2.5.
Ma'am, you got to get the child for DNA testing. All right, because there'll be a DNA testing order. At this point, sir, you're going to pay for it. However, depending on what I may make it half and half or something later on. I'm just not doing. I just want to get it done, and you're the one asking for it, so you'll do that. All right.
Can I speak real quick, sir? I already had I already paid $400 to get my DNA testing done for her. I'm just waiting on her.
All right, get the child in there, ma'am. Do you know where to go and what to do and where he went? And all
Yeah,
that?
I do.
All right,
Yeah,
get it
sure.
done, and then we'll find out what's going on. I'm not offering any parenting time, custody, nothing. I can't until there's a determination that he is the father, and there has to be a paternity order entered. And then we'll deal with that at that point. Or if he's not father, then this goes away. You'll get the child within what, a week in for the DNA testing, ma'am?
Yes, I can.
All right. then, that'll be the order of the court, that there be DNA testing, ordered again, and that, you got a week, ma'am, to get, your child there. All right?
All right.
Good luck, everybody. Thank you. All right. Can both of you hear me?
Yes.
Ma'am, you can? I can't hear you. You're not on mute, but I just couldn't hear you. Say something again. Can't hear you. No, I can't. I can tell you. I think you said, can you hear me now? But that's because I'm reading your lips. I have no idea now.
That I can tell.
Everything's connected here that we can tell. Is your microphone up or something? Whatever. Your microphone, I can only read your lips, quite honestly. And I'm not sorry. That's all right. I know you're trying. See if you can get it on there. I wonder if she should.
She can try logging off and coming back on.
Maybe you should try logging off and coming back on. I don't know. I don't want to. No, I can't hear you. Okay. You'll try logging off, and I'm getting really good at this. Yeah, I could run it without hearing anything. Sure, you don't even have to. You can just mouth it, and I'll figure out what's going on. No, how about?
It's not connected to any Bluetooth device or anything that it would be going through. Are you on a cell phone or a computer?
Laptop.
Do you have a cell phone that you can call in on?
Yes.
Oh, I can hear you.
You can hear me?
Yeah.
Yay.
Apparently just picking up your phone helped. All right, we're here on Johnston versus Flores, Alicia. Both parties are present via Zoom. This is a motion filed by the father seeking a change of custody, basically to 50-50. Says that the parties agreed to 50-50. Is that correct, ma'am?
Yes.
Well, then, you guys just need to go to the legal assistance center or something and do a stipulation and order that says what your custody agreement is. I don't know what it is. You're going to be week on, week off. What 2, 2, 3? What? How are you going to exchange?
3 days on, and then 4 days the next week.
All right. Go down to legal aid here, to the legal assistance center here in town, and send in what's called a stipulation and order. I don't need to make findings on a case where the two of you agree. I think it's probably, you seem like you're reasonable parents and can agree on what's in the best interest of your child. You can do it by what's called a stipulation and order.
Okay. Do we both need to be present at the legal aid for that?
You both need to sign it eventually. Okay.
Okay.
You don't need to necessarily both be present there, but you both need to sign it. And what happens is they'll have a form for a stipulation order. You'll fill out what you want the court to do, 50-50 with 3 days on, 4 days off, then 4 days on, 3 days off, or whatever, and file it with the court. And I can't imagine that I would not sign it.
Sounds good.
All right. Then I know, sir, you've talked about child support. Is there a child support order?
Yes.
Yeah, currently. Yeah, we have been doing this since June 5th. I was wondering if it was possible to get back pay from June 5th until everything was.
Because the custody hasn't even changed at this point, and I cannot retroactively modify child support. All right.
Okay.
I can modify it from going forward. And if you both agree, I don't know what you agree to on child support, or do I need to send it to the friend of the court?
No, we agreed to no, I don't have to pay them. Like there shouldn't be no payment. That's what we agreed on. Once we are doing the 50-50. But I think I understand that there's still some payment that the friend of the court requires for me to pay.
Let me ask this question, ma'am. Are you on any kind of state assistance?
Yes, we have Medicaid and food stamps.
All right, then there will be child support probably, no matter what, because it goes to the state of Michigan, not to her.
But it'll be a low amount for the insurance, right?
It should, well, it'll be the medical insurance cost, okay? but it may also be others because, quite frankly, you're on food stamps too. All right. So I'm going to send this to the friend of the court for their evaluation of it, and we'll see what they do. I don't. Maybe it still would be zero, but you cannot agree to zero child support when the state is helping to fund. Okay, because the money, if nothing else, goes to the state.
Well, legal assistant let me know that there's a paper I can file in order to avoid that payment, and they are covered by my insurance as well. Like I pay whatever.
Yeah, I'm just telling you, if they're off Medicaid, then you don't have to pay it. If they're off state, if there's any state assistance, I won't sign something if there's state assistance. All right. I don't know how much it will be, but if the child's completely off all state assistance, you guys, I don't care what you agree to. All right. Quite frankly, but if there's state assistance, I am going to protect the state of Michigan, if you will, the taxpayers, because they're paying some. So I'll send it to the friend of the court for child support due to 50-50. You guys got to get down here and get that order entered, or else the friend of the court will do it based on not 50-50. All right. Get that in and we'll see what the friend of the court says.
Okay.
All right.
Good luck, everybody.
Thank you.
Good luck. Thank you. Emily Van Roy versus Michael Curtis. Both parties are present. Miss Van Roy is represented by Miss Coletti.
Are you there?
I'm here, but you're not. I don't see you, but work on it here for a minute.
I see it. I saw everybody else a second ago.
You might be able to see me, but I can't see you. Just see if you can turn your camera on. This is the father's motion for parenting time. He says she's not following the mediation agreement. There was a mediation agreement, I believe, that called for minimal time. As I recall, a couple, maybe a few hours once a week or something. Is that correct, Miss Coletti?
Yeah, sure. I think 2 to 3 hours, I believe once or twice a week.
He says he hasn't seen his child for 2 years.
Well, Your Honor, he's got.
I'm just saying what he said. All right, hold on.
It's true what he said.
Right. Sir, I can see you now. All right.
Thank you. Yes, sir.
All right. So you're requesting, you haven't seen the child for 2 years. Doesn't sound like she withheld the child. Why haven't you been visiting?
Well, sir, they have withheld the child, our child. 18 months ago, I had another case come up, and her father said, Mike Van Roy said, I had to take care of that situation before I would be able to see my daughter again and take care of all the other situations, which I did. I followed the court's recommendations. I paid my child support down like the court said I needed to do. And Emily Van Roy, I've been calling my daughter every day for a year, 2 years, excuse me. I've been calling. They changed their phone numbers. Every one of their phone numbers has been changed. Miss Van Roy was the first to change hers. Then now when I call, I use a different number each time when I call, just so that the court knows I am trying to get in contact with my daughter.
All right.
They just up and took her without the courts or anything like that, sir.
So why'd you wait so long to contact the court or the friend of the court to do something about it?
Because I had another case I had to beat first, which Mike Van Roy said I had before I was able to have contact with my daughter. I would have to take care of this, which I did. It was a sexual misconduct case. It was taken care of. I was cleared of all charges. I was never brought up on charges, and I took care of that 4 or 5 months ago. And then I've been arguing with it took me that long, Your Honor, to get the information from the police officers because nobody was telling me any information. I had to go to the Freedom of Information Act to do all the. I had to do a lot of legwork to get to this point, sir. So, I've been trying to get in contact with my daughter, sir.
Ms. Coletti, your response. Hey, I got to start some type of parenting time somewhere.
Well, he's only ever had supervised parenting time.
I understand.
Mr. Van Roy, and if he wants supervised parenting time, I don't believe Mr. Van Roy, Michael Van Roy, changed his phone number. I don't believe Michael Curtis has been contacting him. Yeah, and I also believe that with the CSC case, one of his bond conditions was likely no contact with the child. I haven't seen the bond condition, but that's normally what.
There was no bond condition, sir.
Well, I mean, is that case dismissed? You know, Ms. Coletti, no,
I'm sorry.
One at a time.
Okay, I'm sorry, sir.
Ms. Coletti, do you know anything about that? Was it cleared up, or is there any pending charges or anything?
As far as I know, according to Mr. Curtis, it is cleared up. I haven't verified that with him yet, or
Was it here in Kent County, sir?
I believe it was Allegan.
Allegan? Is that what it was?
I didn't hear the question, sir.
Was the charge against you, was it in Kent County or Allegan?
It was in Kalamazoo County, Your Honor.
Kalamazoo? All right.
Yes, sir.
All right.
I have the paperwork right here, but I don't know if I can show you or not.
You have what?
I have the paperwork from the Kalamazoo County prosecutor attorney saying that I was never brought up on charges. I was never charged with anything and stuff like that.
How about you do this? How about you forward a copy of that or something to Miss Coletti?
Okay, I can do that, Your Honor.
Miss Coletti, does he have a way to forward it to you?
My email hasn't changed. I've represented Ms. Van Roy probably for the past 5 years. So he's.
Can you still have her email? You can forward a copy of it to her?
Yes, sir. I'm pretty sure I'm going through my paperwork right now. I'm pretty sure I have her email. If not, it should be on the paperwork she sent me. See,
yes, it is.
Okay, Your Honor, I almost missed this meeting this morning for some reason. I was never notified of the Zoom meeting. I got a thing from Ms. Coletti, the 19th.
You filed the motion.
Yes, sir.
So you filed the motion. What do you mean you were never notified?
I was planning on being in court this morning. I didn't know the meeting.
Well, if you'd have shown up, you'd be here. All right. I'm just telling you, you're here. You asked for the motion. So
Yes,
I mean,
sir.
It's not like I'm not taking blame for it. We send out the notice and do what we can to get you here. If you would have been here, you'd be here. I don't care. You filed the motion and set the time. So
yes, sir.
Send that stuff to Miss Coletti. Miss Coletti, you're prepared to have him have some type of supervised parenting time to begin with?
Your Honor, it has to be supervised by Mr. Van Roy, and it's, I think he should contact, per the agreement, he should contact Mr. Van Roy to get that set up, and he's entitled, as the agreement, it says 2 to 4 times a month in 2 to 3 hour blocks. This child has only ever had supervised parenting time, so to jump into anything.
I'm not going to jump into anything because he hasn't seen the child for a year and a half, and it was supervised before. So I almost think it would be better, sir, if you had time at Journeys or Safe Connection, because then you could get some kind of report to see how that visitation goes.
Okay, sir. I didn't understand that last part of what you said, Your Honor.
I'm going to give you supervised parenting time with Evelyn. All right.
Yes, sir. Yes, sir.
And they're proposing that supervised parenting time be, say, 2 to 3 hours with apparently her father supervising. Now, that makes it a little bit more difficult because if you want to increase it at some time, you're going to have to get some kind of statement that everything's going well, and that'll be dependent on her father also. The other thing is to send it to an agency for supervision, such as Journeys or Safe Connections. You'd have an hour a week. They'd have somebody there who'd supervise it and would write a report on how things go.
Yes, sir. What was that called? Journeys?
Yes.
Okay. Thank you very much for saying that, repeating that.
It does cost, and we can give as much as possible through the grant, but it can cost you only $30 probably a week, even with the grant, to visit.
Yes, sir.
All right.
I'm sorry. Go ahead, John. I'm sorry.
Ms. Coletti, I think unless there's some real problem, I think Journeys would be a better solution to this, so that everybody'd have to show up there and do that. It would be set. There's no reason not to have that.
Well, I was just thinking that Miss Evelyn knows, has a comfort level with the grandfather. It might be easier for her to see Mr. Curtis after all this time with a familiar parent.
A familiar. Well, I understand. How old is Evelyn?
Evelyn's 9, Your Honor.
9. She's old enough. I mean, I'm just saying that. How else do we get any kind of? You know as well as I do that there's frequently people sent there. Okay, ma'am, you can shake your head all you want, but frequently we have supervised parenting time at an agency such as Journeys, and it provides an attempt also to see how things go from a neutral third party. So you shake your head.
You're throwing her into something that she's has no idea of, what's to happen. I mean, that's very confusing for a child.
She's in a room. Miss Coletti will explain it to you. She's had probably 50 cases where they've ended up in this type of supervision. They're completely supervised. There's no danger. They're in a room with toys or something like that, and they'll be able to talk. And yeah, it'll work its way in one way or another.
He's made no attempt besides calling dozens of times in a row.
I understand, but we're going to start and see how he does. If he doesn't show up, that'll tell me something. If he shows up and they say he's inappropriate, they'll stop the parenting time.
I'm pretty sure he'll try to be on his best behavior. I'm just saying.
I'm sure he will too. All right, as he should be.
To advocate for the child. It's not just about, Michael or I. It really is about Evelyn.
That's right. It is.
And that kind of situation.
And I am providing only supervised parenting time at this time by an agency that does that for a living.
I completely understand that. It's still a very confusing thing for a child.
I'm sure you can. She's 9. I'm sure you can explain it to her. That she just has to go here. You're going to set up a time for it to do it. Hopefully it'll be a regular time, whatever it is, regular every week, 1 hour. And be able to do that. We'll refer it.
This man is a dangerous man. I mean, there's been
he's
many
in a
times
supervised setting. What do you want?
I know. I mean, that eventually.
Well, you're not getting there yet, Miss Coletti. You got to speak for your client. All right. He's not getting anything other than an hour supervised parenting time. That's it. If he tries to do something else, we'll worry about that at the time. I don't even know if he's going to show up. I don't know how often. I don't know what it'll be. Miss Coletti, you got to talk to your client.
I will. Thank you, Your Honor.
I mean, you understand what I'm doing and what there is little to no danger whatsoever. All right. They have rules of when people can be there and stuff like that. And you'll follow them all. And if you don't follow them all, Miss Penroy, you're going to be in trouble. I'm just going to tell you. All right. I'm going to tell you up front. But talk to Miss Coletti. She's been your attorney forever. She's appeared in front of me forever. I've known her forever. All right. I've known her for 40 years. All right. And I know what she does. Listen to her. All right. You're not ever going to be happy, but in this supervised setting, there's no danger your child is going to be injured. If he is inappropriate in any way, they'll stop it. They'll also know what's going on. So we will do a referral. He'll be responsible for the costs, anything that is not covered by the grant. And we'll leave it at that at this point. Both parties have to contact. I can't tell you, sir, exactly when it's going to start, but it should start relatively soon.
Yes, sir. Thank you very much.
All right. Anything else, Ms. Coletti?
No, thank you, Your Honor.
Ma'am, you just got to talk to Ms. Coletti. So good luck, everybody. Thank you. We'll send the referral to Journeys.
So, sir, I just have to get in contact the Journeys place, correct?
Yeah, you'll be contacting. You'll get an order that tells you where and when and stuff to contact them.
Thank you, Your Honor.
Thank you. Thank you, everyone.
Thank you.
We're adjourned.
Okay. Sir, we're done, correct, sir?
You're done.
All right, thank you, sir. You have a great fourth.
You too. Hernandez versus Patton. Both parties are present with the respective attorneys. Mr. Hernandez with Ms. Wagner. Ms. Patton is with Ms. Dubas. We're dealing with a child who I think is about 3. This is mother's motion for custody and parenting time. Ms. Dubas, this was your motion. Anything you want to add?
Yes, Your Honor. So this stems from the domestic violence incident that happened on April 15th between the father and his girlfriend.
Yep, where he was bitten and all kinds of stuff.
Yes. So as you can see from my motion in the police report, the injuries are very severe. The big concern here is that my client was not informed of this incident from the father himself. She didn't find out till one of his family members told him, and then she was contacted by CPS. Prior to this, there had been ongoing issues and concerns with the child and the care of the father. Anyways, the child continually would come home with scratches and bruises and dirty clothes. But then this incident, like I said, given the nature and the extent of the injuries with these children in the home, it was concerning, especially given the fact that the child was released then to his girlfriend's parents. there is a no contact order in the criminal case. We did try to file an ex parte with Judge Hillary upon this incident happening. He did not grant the ex parte in reference to suspending the parenting time. However, he did put in that order that the child is not supposed to have contact with Mr. Hernandez's girlfriend. However, since that time, there's been multiple exchanges where his girlfriend has been seen at the exchange. It's her vehicle with her in the car pulling up to the exchange and then parking down the road. And then Mr. Hernandez walks down the street a couple blocks to do the exchange. And this is since the no contact order in the criminal case and the domestic case. Additionally, it's concerning that he posted her bond as well. Given the no contact order in place, and that this child was, like I said, the night of this incident, released to her parents, which on the bond order, that implies that that's the residence that she's staying at. So we have multiple concerns with him being able to safeguard this child because it doesn't appear that the no contact is being abided by. And then since that time, I've reached out to her criminal attorney because he was the same one that represented Mr. Hernandez in the initial custody case and expressed my concerns about the no contact. Following that conversation, when Mr. Hernandez was supposed to have parenting time, he just didn't pick the child up from daycare on that Friday. So my client had to go retrieve the child. But like I said, just given the violent nature and the number of people that were assaulted, it was not just Mr. Hernandez. It was members of his girlfriend's family that came to the home to intervene that were assaulted as well while these children were all being present. So we would just ask that at this point, his parenting time is suspended because clearly there's two no contact orders in place in the criminal case and a domestic case, and he can't seem to follow either one, and it's putting this child at a risk of harm. And according to the police report, this whole incident started because he was holding his infant daughter that he shares with his girlfriend, feeding her a bottle, and she had the hiccups, and apparently that set this woman off into such a violent rage that she assaulted all these people to the point of giving them concussions. So if she's going to get that upset over hiccups of her own infant daughter, it's scary to think what would happen if she gets upset with this 3-year-old child who we already have concerns about her treatment of the child anyway. And then additionally, it had been communicated to my client as well that because of the nature of the relationship with his girlfriend and this child, the majority of the parenting time that Mr. Hernandez exercises, he has to bring the child to his parents for the weekend and not have her in the home with his fiance. This was prior to the no contact order because apparently it's been communicated she doesn't want the child there. So it appears that when he is exercising parenting time, it's either in the presence of the girlfriend or he's having to ship her off to his family and not keeping the time for himself anyways.
Ms. Wagner.
Thank you, Your Honor. First, my client would adamantly deny that since the entry of the no contact order that his daughter has been around the girlfriend. He is completely complied with that. He brings his sister on to the party's exchange. They have a long history of not getting along. And in fact,
who doesn't get along? The sister?
The parties. The parties have a long history of not getting along.
Oh, you mean Miss Patton and Mr.
Correct.
All right. Go ahead.
So he has brought his sister, and she would attest to that fact that she is the one that's in the car for those exchanges. Ms. Patton was previously charged with domestic violence, in which my client was actually the victim of. So there's some irony in her judgment here because she herself was a perpetrator of domestic violence, and my client did not seek to take away their daughter from her. CPS has been involved, which is the entity designed to protect children. They have closed out their case. They have noted in my communication with CPS that my client was not the perpetrator of all of this, that they have no concerns in regard to his ability to parent. And that the case was opened and closed and no recommendation was made to change placement for any of the children involved in this case. I am not here to defend Mr. Hernandez's girlfriend by any stretch of the imagination. I don't represent her. This isn't about her. It was, however, the first time that something like this has ever occurred. There's not a history of violence. She doesn't have a criminal history of any kind. I do understand that there may have been some alcohol involved and that didn't help matters, but she is complying with her own requirements and doing all of those things. Mr. Hernandez has complied with the no contact order. He has kept his daughter away from his girlfriend and will continue to do so until all of this can be resolved and figured out. But it's not his intention to put her in jeopardy. He didn't intend to put her in jeopardy that night. And I think had he had a crystal ball and known what was going to happen, he probably would have left the home with his daughter. He does work. Just like Ms. Patton does, and he does require assistance with that. He utilizes his mother for daycare when he does have to work, and that's where his daughter spends time. And he does not believe that his parenting time needs to be suspended by any stretch of the imagination, nor even supervised, because he has done everything this court has asked to protect his child.
Ms. Dubus, do you have some kind of video or something showing that the girlfriend's around? Because quite frankly, he denies it. Your client says it is, and I don't have any idea. If the girlfriend was around, she would clearly be at danger of being arrested for not only, well, primarily for violating a court order of bond. I assume what you're saying, Ms. Wagner, is there's a bond order that does not allow her around him.
That is correct.
What
Your Honor,
evidence do you have?
They use a third party for exchanges, and on the 2 occasions, it was a different party. So 2 different parties that witnessed Miss Aguilar in the car.
Who are these parties?
It is a coworker of Miss Patton and her mother.
And she uses them, but he's there?
Correct. She does not go to the exchange. She has a third party go.
All right. Well, it's really clear that the judge ordered at the ex parte order that the girlfriend not have any contact or be around the child. That was right in the ex parte order, correct?
That is correct.
Understand that? Mr. It says Diego Munez.
Yes.
So you understand that, don't you?
Yes, I do, Your Honor.
Any time, if she's found to be around that child, you're going to lose your parenting time. You understand that?
I understand, Your Honor.
All right. Well, I'm not really eager to penalize somebody for being a victim of domestic violence. You know, and he's clearly the victim in this, and I don't know that he deserves to lose time with his child because of it. As long as he follows the order. And I got to have some kind of proof that he's not. And if there is some kind of proof that he's violating a court order, you can file an order to show cause on him, and you can have a trial and everything and see if you can prove it. I'm not going to change anything at this time, but I am going to tell you, sir, that if she is around, I don't care if she's 2 blocks away and she can see her and stuff like that. If your daughter's around that woman until further order of the court, she cannot be around her. Do you understand that?
Yes, Your Honor.
So I'm going to deny that parenting time be supervised at this point. I'm going to find that I don't have enough to deny or to warrant him having supervised parenting time. As far as change of custody, I don't know if you're asking for that. Also, there's one incidence of violence. The child was not a part of the violence. I want to say was not the subject of the violence, at least at this point. If you can show me something, Miss Dubus, that there is some CPS report that substantiates some of the stuff you're saying, or, you know, he's done something wrong, we can revisit it. But at this point, I don't have anything other than he was the victim, and that the court has made an appropriate order. I think Judge Hillary's order is appropriate at this time to keep that woman away. So I'm going to deny your request at this point for change of custody or parenting time. I don't find that there's a change of circumstance or proper cause that would warrant a custody hearing at this time. There's one incident where he was a victim, and as long as that doesn't happen again by the girlfriend, or the child's not exposed to it, that's fine. Any other time, you don't get a second bite of the apple.
Can I say something, Your Honor, please?
Miss Dubus, your client wants to say something. I'm not inclined to. You're not going to argue with me. That's my order, but you can say something.
That's okay.
I'll speak with her after, Your Honor.
All right.
I did have one thing to address though, and I don't know if you can answer this or not, but my client did recently move, and she tried to change her address with FOC and wanted to make it confidential. They told her she would have to file a motion to do that. Can we include that in this order?
Ms. Wagner, do you have any problem with her having a confidential address to a friend of the court?
I do not.
Okay.
Then she may have a confidential, and you can include that in the order that she can have a confidential address.
Okay.
Right. Anything else by either of you, Ms. Wagner? Anything you wish to address?
No, Your Honor. Thank you so much.
Thank you, everybody. Good luck. Have a good afternoon.
You too.
Matter of Taylor versus Taylor. Mr. Taylor is present. Mrs. Taylor is not, or Ms. Taylor. This is the plaintiff's motion to terminate child support. Sir, did you give Ms. Taylor notice of this motion?
Yes, I sent the notice to her in the mail.
When did you do that?
When I filed for motion to circuit court a couple weeks ago, or when I filed this motion.
So it was like, I mean, most of the stuff is dated here 6/10. Is that
correct? Yes.
So have you heard from her at all? I mean, does she object to this?
No, she doesn't object to it, but unfortunately, after being divorced for 6 years or so, we're not on speaking terms, unfortunately. So,
right, well, I mean, because it seems like a fairly simple motion. You've asked to have child support terminated because your child Blake graduated from West Catholic High School.
That is correct.
At the end of May, and he's already 18. He turned 18 in February. That's correct?
That is correct, sir.
All right, so child support will be terminated. I can't backdate it, but your motion was filed on 6/10. As of 6/10, child support will be terminated. I'll get an order over to the friend of the court indicating that.
Yeah, I did send documents to friend of the court, but they said that I had to file a motion in circuit court because of my divorce decree stated he graduated 2000. He's graduating 2025. So I just wanted to.
I understand that's the best. I mean, I'll get it over to them. They'll probably take some support out for a little bit here because nothing stops or starts really fast. We'll get an order to the friend of the court that your support is to be terminated as of the filing of this motion. And actually, I'll probably do it as of 6/1.
It should be 6/1. So, but I don't know if you know the workings in front of the court, but they said I'd be reimbursed. Do you know anything in regards to that, or
that's up to them? All right, I'm not going to reimburse you from my pocket. So they'll do the best they can.
Nor did I never say that. So
I understand you work with a friend of the court on it. All right, they handle the money.
Yep. Yes, sir.
And so we will get something over there. I may even contact the attorney and say, "How about stopping this, guys? Because it's coming over." But
yeah.
That's what it will be. All right.
Okay. All right.
Good luck. Thank you.
I appreciate it. Thank you.
Matter of Kerr versus Sarek. Mr. Sarek is present via Zoom. Miss Kerr is not. She was given notice of this motion, correct?
Yes, sir.
And like more than when did you mail it to her or something?
The court did that for me. Motion regarding on 6/13.
All right, I see she has a confidential address, so they mailed it to her on 6/13, you say, and we're the 28th, so there's sufficient notice. Sir, I'm trying to figure out, is your child 18 now or what?
She is, yes.
Laura is 18?
Yes.
And you know if she's still in school or whatever?
So she did a program where she didn't graduate this year. She has to do a 5th year at community college before she gets her diploma. So she's supposedly still committed to doing a year at GRCC through her high school. It was like a 5-year high school program that she chose to do.
All right, well, and she does not live with was she in a guardianship or something?
Yes, they did obtain guardianship, her aunt and uncle, over her.
And that guardianship, do you know, has that been terminated or?
I don't know anything about that. All I know is her aunt and uncle texted me a few days. It was probably like 6/11 of they texted me and said, "Hey, just to let you know, Laura no longer lives with us." And they said they sent a letter to the court, but I had to file.
How the court works. So, all right. Well, based upon your statements, the child is 18. While she hasn't finished high school, she's not living with the person that you would be paying on a full-time basis. Do you know where she's living?
I do not. Her aunt and uncle, I believe, kind of turned her against me, and she hasn't talked to me since before, around the time they filed for guardianship of her.
All right, well, the guardians have contacted, Mr. Sarek here. And did you notify them of this hearing?
I thought that's what, the court was going to, serve them papers, I believe.
I don't know why the court would do that, but.
Well,
We don't do a lot, setting these things up. It's up to you guys to set them up. All right. So you're not sure if the guardians were even notified of this? Because if, raise your right hand for a minute, all right? That's your other right hand. All right, good luck. Do you solemnly swear affirm the testimony given in this case to be the truth, whole truth, and nothing but the truth?
Yes, sir.
All right. It's your information through the guardians of Laura that Laura is no longer living with them. Is that correct?
That is correct, sir.
They contacted you about it?
They did.
They contacted you earlier this month and told you she's not living there anymore?
Yeah, they said as of 6/1, Laura no longer lives with us.
All right. And based upon that, her being of age, being 18, there's no reason that father should be paying child support to guardians where the child does not live. So I'll stop child support as of 6/1. We'll see what happens.
Okay.
Your testimony is that she's not living with the guardians, and I don't even know if the guardianship has been terminated or what, but we'll see with that. All right.
Okay.
All right. I'll do my best. We'll do an order to the friend of the court terminating child support, and if something else comes up, we'll deal with it at that time.
Okay. Thank you, sir. I appreciate
it.
Yep.
Bye. DP, it's the matter of Rodriguez versus Segura. Mr. Segura is here via Zoom. Ms. Rodriguez is not. I've been told by my clerk that a while ago she did log in, but she's logged off and she's not here anymore. This is the defendant's motion for a temporary order dealing with the child Julian. Sir, you're asking for a temporary order. There's a DNA test that's been ordered. Have you completed it?
Yes, Your Honor.
Has there been an order? Has there been an order of paternity?
Can you have that in Link's terms?
Has anybody filed an order that makes you the father?
Yeah, that's been still waiting for results to come back.
Oh, all right, then nothing can happen until you're the father. I'm not giving anybody custody, parenting time, anything. You're not legally the father.
No, if it was for one, but I've been there for all his life, and knowing that it is my child, I know I get it with the whole DNA results. It's been tough, especially not
Should have
seeing.
done this years ago, or agreed to a affidavit of parentage or something. But quite frankly, I can't order parenting time for somebody who has not been determined to be the father, legally determined to be the father. So once something happens and there's an order of paternity, maybe you want to come back. But I can't order parenting time for somebody who is not legally the father at this point.
And she's kept us away for a while, so I know I get it, Your Honor.
I just can't. All right, you're not the legal father. I'm not the legal father. I couldn't order parenting time for me unless I could show that I was the legal father. All right. So
yeah,
nothing to do about this. So I guess at this point you want a temporary order, and I'll deny it at this point because I can't. I just can't.
And then to file this motion once again, would that take a long process of that?
I guess what I'll tell you is that we'll deny it without prejudice. If you really want to renotice this, maybe it'll help you from having to pay the filing fee again.
Okay, thank you, Your Honor.
All right, so can't do anything until you're established as legal father.
Okay, thank you.
All right, good luck. Thank you.
Thank you.
SDS matter of Severa versus Nickens. The plaintiff is present via Zoom. This is her motion for an objection to the friend of the court recommendation. Did you give this motion to the defendant?
Yes, I mailed it out and got it certified.
When did you do that?
The same day, so on 6/14/2024.
All right. So he has notice of it?
Yes.
This is your objection to the friend of the court, recommendations that were submitted to the court. I'm not sure that I follow all the objections, but quite frankly, I can't enter an order from the Kent County friend of the court if you object to it. And you've made objections regarding, I think, child support, parenting time, things like that. So I won't enter that order. We'll have to set up an evidentiary hearing regarding custody, parenting time, and child support.
Okay.
Nothing else I can do. So you'll get notice of an evidentiary hearing to come in for these various items such as child support and whatnot. All right.
Okay, and is it possible where we can do a DNA test?
Nobody asked for a DNA test.
Because I put on the paperwork the situation that he was saying and responding that, you know, it's not his kids now and that he doesn't want no parts of them or anything like that.
Well, let me ask you, is that his kid?
It is his, but I don't know where is this coming from him, just out of nowhere.
It would be up to him to file something. I mean, you're saying it's his kid.
Yeah. And not only that too, I guess right now my boy's Social Security income is postponed at this moment due to dad, Mr. Nickens, keep going to Social Security 3 times in the whole month of May, demanding money where he not knowing he's being recorded and monitored. So right now it's postponed until I show him copies that I still have legal custody of my boys.
Well, you objected to the friend of the court recommendation. I don't know what the friend of the court recommendation was, but we got to have a hearing on it because you know,
yeah,
that's what it is. I don't know what else to tell you.
Okay.
All right. This was a DS case. I'm sure it says probably in the initial order that the petitioner shall have initial custody without prejudice of determination of either parent's legal rights. That would be you that has initial custody without, you know, figuring out further things through and I sent it to the friend of the court, and I don't know did they recommend you have custody or what?
No, they didn't say they have any paperwork or anything like that. I even went down to the 2nd floor to see if they have any paperwork, and the only paperwork they only gave me was for Jonathan Nickens Jr. that only have
you must have gotten stuff from the friend of the court because you filed an order, you know, you asked that you object to the friend of the court's recommendation.
Yeah, the only reason why I objected because by him saying that him and another third party is going to swab my boys without my permission, and not only that, before my son Ian Nickens came to me on May 10th, I guess he was going to take my son to live with him in Muskegon, which I didn't know anything about that until CPS told me about that before the case was closed.
What? See, I'm not sure what you objected. If the friend of the court gave you everything you wanted, why you're objecting to it?
Yeah, like I said, I didn't mind because I love the time that they had. Like basically 1 week he has the boys and 1 week I have them, which I agreed on that, you know. But the thing is, like I said, on the text messages, the paperwork that I sent to you, like he just did a whole 360 out of nowhere, just out of nowhere.
I'll just warn you that when I have this, it's not going to be anything about that. It's going to be to determine who has custody, physical and legal custody, and what parenting time is and what child support is. That's what I'm going to have a hearing on, not whether or not he says he's going to take the child or all this stuff. I'm going to make a determination on that. And until then, you live with what is out there right now. So we'll set up an evidentiary hearing for you. Make sure you follow what is on the notice. You got to have certain times. I will tell you in all honesty, it's foolish not to come in with an attorney because I can tell you right now, you don't know.
Yeah, I really don't.
Admissible evidence and stuff like that. You may want to go try starting out with maybe with legal aid.
Okay.
Something. All right. But
okay.
We'll send you notice when the hearing is. We'll see you then.
Okay. Thank you.
Thank you. Fonseca Megana versus Garcia. This is a motion that has been sent in by the plaintiff. Ma'am, did you try to give notice to the defendant on this case? Did you try to send it? I understand he's been deported and has been out of the country since 2015.
Yes, I trying to send for the messengers.
Okay.
He's never answered anything.
You haven't had any contact with Mr.
No.
Garcia in almost 9 years? I mean, you said he was deported in 2015.
Yes.
And you're now seeking a ROPA motion to find that because you filed for a divorce and you have 2 children who were born during the marriage to Mr. Garcia, right?
Yes.
And those kids are 4 and 5, and unless he came up here, it would be unusual that he's probably not the father. All right.
Yes.
Here, and normally I have to order a DNA test, and I'm going to order a DNA test, but normally I would do it between your husband and the kids. However, you tell me that you know who the father is. Is that correct, of the 2 kids?
Yes.
Can you get him to do a DNA test so that he would do it and the kids would do it, and then you could show it to me and it's, he's clearly the father?
Yes.
Do you have contact with him?
Hold on. Yes, it's fine.
So what I'm saying is, Mr. Quintino,
Yeah.
you're saying is the father.
Yes.
Why don't we have a DNA test with the 2 kids and Mr. Quintino? If it comes back that he's the father, then I can do saying that Mr. Garcia is not the father, and you can proceed with the divorce that way.
Yeah, the Mr. Garcia is not the father.
I understand he's not, but I got to have some proof.
Okay.
Okay. And I can get it by either Mr. Garcia, which I'm not going to get it from him, or Mr. Quintino, who obviously would show that he is the father, right?
Yes.
So we'll do a DNA test with Mr. Rigoberto Vargas Quintino and the kids. Once you get that back, come back in and we'll make him the legal father.
Okay.
Who did? Oh, Mr. Quintino had logged in quite a while ago, but he's gone.
Yeah, he's working right now.
Right. Well, tell him that he's going to have to take a DNA test, and you guys put it together. We'll send you an order so that you can do a DNA test and get it back to me. Okay. Make sure it's a correct test. Okay. I mean, we got to know that it's him that's doing it. All right. And then we can take care of it. It's pretty easy. All right.
Okay.
Thank you very much. We're
Bye.
adjourned.